Welcome to Employment Law This Week. I'm George Whipple. Our top story, the 11th Circuit opens the door for disparate impact claims from applicants as well as employees. The court allowed an age bias claim to go forward against Reynolds Tobacco Company from an online job seeker who was rejected repeatedly for employment. Company guidelines allegedly directed hiring managers to target people who were 2 to 3 years out of college and stay away from applicants with 8 to 10 years of experience. The plaintiff is arguing that these guidelines have a disparate impact on older workers and led the company to reject his application.
As a consequence of this decision, also with taking into account the EEOC's focus on recent years on fighting what it calls systemic discrimination, employers on a regular basis need to be looking at their policies. Here we're talking specifically about hiring and recruiting policies, job postings, to ensure that there isn't a potential disparate impact claim lurking there, and also to be sure that those policies can be justified by reasonable business factors other than the protected category and issue.
This week, the United States Supreme Court heard arguments in the affirmative action case Fisher versus University of Texas. We will be following up in later episodes on issues surrounding applicants and affirmative action in employment in light of the possible implications of this case. 2 recent cases in the new and evolving law around wellness programs. First, clarity on GINA from the Fifth Circuit. A paramedic with the San Antonio Fire Department sued his employer after he was placed on alternative duty for refusing to take a physical exam as part of the department's wellness program. The Fifth Circuit ruled that GINA prohibits tests that examine DNA and other structures within human cells, but not medical tests like those for cholesterol or blood counts. And Orion Energy Systems and the EEOC both moved for summary judgment in their ongoing wellness program penalty battle. Orion offered a wellness program where the company paid the health insurance premiums of participating employees who took a medical exam. The plaintiff refused and therefore had to pay more than $400 per month to cover her insurance premiums, along with a $50 monthly penalty for refusing the fitness part of the program. Orion claims that the medical exam was voluntary, but the EEOC contends the financial consequences made it involuntary and illegal under the ADA. The New Jersey Supreme Court could limit an employer's right to put contractual time restrictions on employee suits. 9 months after his termination, a former employee of the Raymore and Flanagan furniture chain sued the company for alleged disability bias under the New Jersey law against discrimination. Despite the 2-year statute of limitations under the law, the employer included a 6-month time limit in their employment application. After the furniture company won a victory in the lower courts, the New Jersey Supreme Court is considering whether the time limit is enforceable. Increasingly, courts around the country are scrutinizing contract terms between employers and employees. We'll keep watching this one to see how the High Court rules. And that brings us to our tip of the week. Here's Heidi Hayden, Chief People Officer at the National September 11th Memorial and Museum, with some advice on supervisor and HR roles in handling employer relations.
For many reasons, including the avoidance of legal issues, it's important for employers to maintain positive relations with their employees, and it's especially important when addressing discipline issues. Human resources and supervisors both play vital and important roles in this process. Supervisors will generally identify performance, attendance, or behavior issues, decide on a course of action, and consult with human resources. Human resources will act in a consulting capacity, talking through the recommendations. They'll ensure consistency with policies and procedures, and they'll also consult with legal as appropriate on applicable laws or contracts that should be considered. Supervisors can support positive relations through the discipline process by maintaining open communication, by ensuring that they communicate clear work expectations, fairly and consistently applying policies, and of course consulting with human resources.
Thanks, Heidi. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.